Hi folks, Hassan here on the HMA Law Firm channel. Thanks so much for tuning in. Our question today, my son or my daughter was born in the United States. Can I get some papers? Can I get status? Can I change my status? What does it get me? We get this question a lot, and many people who reach out to our firm, they might have heard things from their friends or family. They might have read things online, seen news reports, et cetera. And here's the crucial takeaway. Just because you have a child who was born in the United States does not by itself give you the right or the ability to apply for a green card. There's a lot of misinformation out there that say that if you are the parent of a U.S. Citizen child, and I've heard these kind of misconceptions from attorneys as well, maybe not immigration attorneys, but other attorneys who think that if you have a child born in the United States, that you cannot be deported. And let me say it very, very clearly. It does not give you the protection that you might think. Yes, parents do get deported away from their U.S. citizen children, and it happens all the time. Now, I think it's horrible that that happens. I think that the law should say that having deep roots in the United States, raising children in the United States, should give you the ability to, just based on that, apply for some way to remain in the United States. But unfortunately, as it stands now, the law does not say that. Where it gets confusing for people, and I think this is the reason why the misconceptions form, is that it is possible when the child is 21 years of age to sometimes, not always, sometimes petition for their out-of-status parent. But the rules as to whether or not the parent will be able to get a green card based on a U.S. citizen child who's over 21 years of age, sponsoring them or petitioning for them are very, very complex. You should check out our video on adjustment of status, which is the process of filing for a green card inside the United States, to learn a little bit more about how complex it is. So we get this question a lot. Well, I have a child. Maybe the child is over 21, and can they sponsor me? And the answer to that is, well, sometimes, but we still have to look to see whether or not, based on the way the parent came into the United States, what their immigration history is, when they came in, because the laws have changed over time, and of course, whether there's any removal orders or court dates that were perhaps not known about and weren't attended. There's a lot of different things that have to be looked at in order to make sure to find a pathway to a green card if you have a child who's over the age of 21. Sometimes having a child who's under 21 might indirectly help you if you're applying for another form of relief, such as cancellation of removal. Sometimes you have to have what's called a qualifying relative in order to apply for a hardship waiver or for cancellation or some other form of relief in immigration court. So sometimes having a U.S. citizen child can help you qualify for that, but you still have to meet all the other requirements, and you still have to be able to show that you deserve that form of relief. So it's like so much in immigration law. The answer is it depends. But the main takeaway here is that simply because you have a U.S. citizen child, whether they're under 21 or over 21, that by itself does not give you the right to apply for a green card. I wish it did, and unfortunately that's not the status of the law right now. So the best thing that you can do is, before you try to apply for anything, before you try to send an application for a green card to USCIS, is to have a consultation with an attorney who can ask you all the questions, some of which you might not even know to ask, right? To go through your history and figure out whether or not there's a way that you can qualify for a green card. I can't promise that there is a way, but if there is one, we'll find it. Thanks so much for tuning in, and remember, prosperity is a human right.